morning, everyone, and welcome to 3PB's Disability Discrimination Law Update webinar. My name is Karen Moss. I am the Deputy Head of the Employment and Discrimination Law Group at 3PB, and I'm joined today by Grace Boorer, who is our nearest brilliant tenant, having just joined us from Old Square Chambers earlier in the year. I wanted to start off by letting you know that the slides from this webinar will be sent to you afterwards, so no need to be scribbling away as to what we've written on the slides. And also we're being recorded, so a recording will be sent to you if you want to come back to any points later on. In this webinar, I will be racing through section 15, trying to give will be a reminder, an overview of liability under that section, and also trying to deal with the latest cases in relation to discrimination arising from disability. Grace will also be doing a case law update on disability discrimination in the wider sense. I apologise as there's a lot to get through, and so Grace and I have been trying obviously to summarise as much as possible. There might be some whiplash as a result of the speed that we're travelling. We apologise for that, but hopefully we'll have time for some questions at the end of the session. If possible, could you use the Q&A icon at the bottom of your screen and submit any questions that you might have whilst we're talking, and then at the end of Grace's talk we will have a look at those questions and answer those if we can before the end. We do want to end promptly at midday to let you all get on with your lunch. So I'm going to start now by sharing my screen if I can. So hopefully you will see there the title for the webinar, and that is an update on section 15. And what I will cover specifically is firstly knowledge under section 15. Again, this is a massive and very controversial subject. Secondly, what constitutes unfavourable treatment in light of the most recent cases. Thirdly, this is really what distinguishes section 15 mainly from many of the other sections within the Equality Act. That is the causal links that are required between the various elements. And then finally, justification, particularly in light of DWP and Boyers. So, knowledge to start. Now, obviously the starting point must be the statutes, and looking at the familiar section 15. There is obviously a defence if the employer shows that the employer did not know and could not reasonably have been expected to know that the employee had the disability. We know that what that means is only knowledge of the disability, so actual or constructed knowledge of the disability itself is required under section 15. What that means is what is not required is like in relation to the duty to make reasonable adjustments, where what is required is not only actual or constructive knowledge of the disability, but also actual or constructive knowledge of the substantial disadvantage. Under section 15, there's no need for the employer to know that the employee is under a substantial disadvantage. Secondly, and importantly, no knowledge is required of the causal link or links between the disability and the unfavourable treatment. Just a reminder of Dr. Pneza, when I represented her in the AT, her position was that she had been given a negative reference by a previous employer because of her sickness absence, which was disability related. The prospective employer, who's NHS England, accepted that negative reference, acted upon it by refusing the offer of employment. NHS England didn't know that the negative reference arose in consequence of her disability, but nevertheless, because probably they didn't plead justification, liability nevertheless attached to both the entity which wrote the reference and NHS England, that is, who acted on the basis of that negative reference. So moving on to occupational health reports, we've known for some time since Gallup and Newport that an employer is not able to blindly rely upon an occupational health report in relation to where an occupational health doctor gives an opinion on disability. In Gallup, the occupational health practitioner there gave the opinion that the claimant was not disabled. As a matter of fact, that claimant was disabled, and the tribunal found, and indeed the Court of Appeal found, that the employer could not rely upon the occupational health report to escape liability by saying they didn't know about the disability in that case. However, to the relief perhaps of some employers, Donnellian was decided in the Court of Appeal in the last couple of years, and what the Court of Appeal decided in that case was that great weight can and should probably be attached to a well-reasoned and informed occupational health report, and employers are entitled to rely upon those reports as long as they also consider all the other circumstances. This isn't a rubber stamping, but they are entitled to look at the occupational health reports and take note of what is said there. In relation to the burden of proof, this is probably obvious. I'm sure you all know, because it's a defence. It is for the respondent employer to show that they did not have knowledge, rather than for the claimant employee to show that an employer did. Moving to the most recent cases, A Limited and Z is an interesting case because it involves an employee who was reluctant to tell her employer about her mental health difficulties. She had had quite considerable time off, and as a matter of fact, all of it was related to her mental health condition. Nevertheless, she didn't want to tell her employer about that condition, and therefore gave various reasons for her absence. She, for example, mentioned various physical ailments. I think she did mention stress and anxiety as well. Some of the fit notes from the GP mentioned general anxiety and stress, but what the employment tribunal found is that the employer could have done more to find out the real reason behind the claimant's absence. However, what the tribunal also found is that even if the employer had made those extra inquiries, those reasonable inquiries, the claimant was likely in the circumstances to have done the same as she had done previously, that is, essentially to have lied about the reason for her absence. Nevertheless, in the employment tribunal, they found that the respondent employer did have sufficient knowledge because they found they could have done more to find out. In the employment appeal tribunal, the appeal was allowed because what the employment appeal tribunal said is that the question is not what the employer what the employer ought to have done in terms of making further inquiries, but what might the employer then reasonably have been expected to know once they've made those inquiries. And in those circumstances, the Employment Appeal Tribunal found that the knowledge test was not satisfied, and as I say, the appeal was allowed. Moving to Balde in the Employment Appeal Tribunal last year, what was interesting about this case is that Ms. Balde was concerned about her dismissal, but her employer, Ms. Balde alleged in the Employment Tribunal that her dismissal was discrimination arising from her disability. The employer didn't have any knowledge at all of her disability until the appeal stage. Now, Ms. Balde, and perhaps this might make this case distinguishable from others in the future, because she represented herself throughout the tribunal proceedings. She pleaded her own case, and the only action which she said was unfavourable treatment arising in consequence of her disability was the dismissal. When we got to the Employment Appeal Tribunal, what I argued was that the rejection of the appeal, although it wasn't specifically pleaded, was part and parcel of the unreasonable treatment complained about, and it was incorporated within the complaint of dismissal. Ms. Balde had a mental impairment which she argued caused the misconduct that she was accused of, and at the appeal stage, although she said nothing at all throughout the disciplinary process, I think it was at the end of her probationary period, at the appeal stage, she referred to a previous mental breakdown that she had suffered. And she also suggested that the reason she sometimes was flustered or difficult with colleagues at work was related to that. The tribunal, when Ms. Balde was unrepresented in the tribunal, found that she had not said enough at the dismissal stage, and therefore the respondent escaped liability under Section 15 because they were held not to have actual or constructive knowledge. The Employment Tribunal failed to consider what the state of the employer's knowledge was at the appeal stage. What employers should do in light of Balde if there is a suspicion or any reasonable grounds for suspecting that the employee might be disabled, even if it's as late as the appeal hearing, they should nevertheless, to be on the safe side, review the decision at dismissal stage to determine whether they could justify a decision which which meant that Section 15 was engaged. Moving to the next slide of Tesco stores and tenant. This was actually a case which didn't involve knowledge. It was an appeal which arose after a preliminary hearing concerning whether a claimant was statutorily disabled. In that case, it was interesting because the claimant was suffering from a mental condition, I think depression, for a year between September 2016 and September 2017. There was no evidence that she had suffered from depression before that period, and the tribunal found that she was therefore disabled throughout that year. So when various acts took place, they were actionable. The respondent employer appealed, and their appeal was on the basis that there was no determination of when that mental impairment became one which was likely to last at least 12 months. because although the impairment in fact lasted 12 months, there was no determination as to when it satisfied the long-term condition under Section 6. In my opinion, Tesco and Tennant does have an implication for knowledge. It's an interesting one because if, for example, there is a knowledge, or perhaps constructive knowledge, of a mental impairment like depression at the beginning of a period, but no knowledge that it is the kind of condition which is likely to recur or indeed likely to last at least 12 months at the beginning of the period, then I think it'll be a tricky point for tribunals to grapple with as to when, not only when did the disability become when did the impairment become a statutory disability, at what point did the condition become one that was likely to last 12 months, but also whether the knowledge was one not only of simply an impairment, but of a disability. Again, they might not coincide, those two dates, and it's one I think to watch in the future. Dealing with unfavourable treatment, so moving on to what can constitute unfavourable treatment. You're probably all familiar with the Supreme Court decision in Williams and Trustees of Swansea University. This was delivered again last year. Mr. Williams, in that case, was, as a result of his disability, entitled to take an early pension, but he complained that he was treated unfavourably because that pension was based on his part-time salary, because at the point that he was retiring, he was working part-time as a result of his disability. And he argued that had he not been disabled, he would have been working full-time, and therefore his pension should be based on a full-time salary. The Employment Tribunal liked that and found for him. He succeeded in Cardiff, and then he failed in the Employment Appeal Tribunal, Court of Appeal, and again in the Supreme Court. What the consistent message throughout all of those appellate levels was that treatment that was advantageous cannot be said to be unfavourable because it was insufficiently advantageous. Essentially, Mr. Williams was being given preferential treatment to non-disabled employees because he was able to take an early pension. And so although he would have preferred to have an even more generous provision, that wasn't the same as saying that he was subjected to unfavourable treatment, and therefore Mr. Williams failed. And the appeal succeeded in the AT and was upheld thereafter. A useful clarification came from the Supreme Court in Williams from Lord Carnworth. He clarified a point that had been slightly muddied, particularly in a Court of Appeal in Williams. Unfavourable treatment and detriment are said to be analogous concepts. So there should really be no distinction drawn between those two concepts. And that means that employment lawyers looking at disability discrimination, or indeed any other discrimination cases, can look to the whistleblowing authorities to assist when considering what constitutes unfavourable treatment. Looking at the updated position, as it were, the Employment Appeal Tribunal applied Williams in the case of Chief Constable of Gwent Police and Parsons earlier this year. That was another case which involved early entitlement to a deferred pension. In this case, it was two policemen who were also disabled. And as a result of their early entitlement, the Chief Constable of Gwent Police applied a cap to the pension entitlement. and the claimants in that case argued that that was unfavourable treatment which arose in consequence of their disabilities. The Employment Appeal Tribunal, and far be it for me to argue with the Employment Appeal Tribunal, found that the Parsons case was distinguishable from Williams because they said that it was the capping of the lump sums that was the unfavourable treatment, the relevant action that was relied upon, and that was said to be unfavourable, whereas in Williams there was instead a reliance upon taking the deferred pension, which of itself wouldn't have been available to any non-disabled colleagues. I have to say, I find Parsons a little difficult to reconcile with Williams. I don't know if Parsons is being appealed to the Court of Appeal because I think it's too early to say at the moment. But I'd be interested, we might need to watch this space in relation to that one. I have added the case of Jasuderson and Alderhay Children's Hospital. It's a whistleblowing case, but it's very recent. Again, I think it gives us assistance as to what can constitute unfavourable treatment. Obviously, in a whistleblowing case, technically that's a detriment rather than unfavourable treatment. In that case, Dr. Jasuderson had sent complaints about professional standards at Alderhay to various third parties. The hospital, obviously feeling rather affronted by that, contacted the same third parties and wrote to them saying that the complaints of Dr. Jasuderson were completely without foundation. The Employment Tribunal found that that was wrong because an independent report had recommended that improvements should be made, and in fact that report was taken seriously by the hospital, so it wasn't true that the complaints were completely without foundation, and in any event they found that those letters were capable in themselves of constituting a detriment, and therefore Dr. Jasuderson succeeded in that appeal. Moving on to the causal links required under section 15, I have half a mind on the time, so I'm going to take this one relatively quickly. We're probably all familiar with the line of authority from Peneza to Risby up to the Court of Appeal in Grosset and City of York, so I don't intend to go to those in any detail. But I did want to refer to IFORCE and Wood, decided last year in the Employment Appeal Tribunal, because I think there was a concern that there was a momentum created by the previous cases, which meant almost that employees couldn't fail to establish a link between their disability and the unfavourable treatment. Certainly Grosset and Risby were criticised in the legal press for being too tenuous a link. In IFORCE and Wood, Mrs. Wood had, I think it was arthritis. She was asked by her employer to move to a different position within the office. She refused, and she refused on the grounds that she thought that where she was being asked to move to was going to exacerbate her disability, because she thought it was going to be colder and damper than where her desk was previously situated. She therefore refused to move, and her employer ultimately disciplined her for refusing a reasonable instruction. When it came before the Employment Tribunal, interestingly, the evidence was that the proposed position of her desk would not in fact have exacerbated her condition of arthritis. It wasn't in fact colder or damper. As a result of there being a lack of objective link between the disability and the refusal to carry out the instruction, the tribunal and the Employment Appeal Tribunal found that there was a break in the chain of causation, and therefore Mrs. Wood could not succeed in her case under Section 15. So although I think that's a slight kind of drawing back from the trend that we've seen in appellate decisions on causation under Section 15, I think there must still be caution exercised by employers. The protection under Section 15 is extremely broad and remains extremely broad due to the fact that there does not need to be a direct causal link between the disability and the unfavourable treatment. It can be very much indirect. In the case of Sheikh al-Islami, Lady Justice Simler said it better than I ever could, and I've set out the quote on the slide. The critical question in that case was whether, on the objective facts, her refusal to return arose in consequence of, rather than being caused by, her disability. This is a looser connection that might involve more than one link in a chain of consequences. Finally, I wanted to deal with justification and the case of DWP and Boyers. This case was argued in the AT by our very own Stephen Wyeth and was before our very own Matt Gullick. What happened in that case is there was a dismissal during the claimant's sickness absence, and it was agreed that Section 15 was engaged, that is, that the sickness absence was caused by her disability. And therefore the respondent was pinning their hopes on justification arguments. The tribunal accepted that the DWP had legitimate aims, but they did not accept that the dismissal was a proportionate means of achieving those aims. The Employment Appeal Tribunal found that the tribunal had erred, because what they did is they failed to balance, on the one hand, the legitimate aims and the real business needs of the respondent as against the discriminatory effects of the dismissal. Without that balancing act and without express reference to that balancing act, it's going to be very hard for an employment tribunal decision to stand on justification. In the Boyers case, the appeal tribunal found that they were focused too much on the decision-making process, which they said was flawed on the part of the employer, instead of deciding on an objective basis whether the legitimate aims were achieved by proportionate means. That is my final slide. I'm sorry I have taken half of the time we have, but I shall pass over to the brilliant Grace Boorer now to deal with her case law update. Thank you.
Thank you very much, Karen. That was a really excellent overview and update on Section 15. I'm going to continue now with the theme of case law update. So if I can load up my presentation now. Lovely. So hopefully you can now all see the start of my presentation. As I say, I'm going to be continuing with the case law update, as there's been a number of different EAT and Court of Appeal cases recently on disability discrimination. So I've chosen some of the key ones and hopefully can give you an overview of those decisions and also some practical outcomes of those cases as well. So the 4 topics that I have chosen as set out on this slide. So we're going to look at defining disability, PCPs, extension of time arguments, and recommendations as well. So firstly, looking at defining disability, before moving on to kind of two key cases in this area, I just wanted to kind of run through the background of this area first, very briefly. I'm sure you're all very familiar with this, but it's also always helpful to go over things again. So under Section 6 of the Equality Act, in order to establish disability, it must be shown that a person has a physical or mental impairment. So impairment is number one, and number two is the adverse effect, which has to be substantial and long-term and have that effect on normal day-to-day activities. Now, the key case so far that has sort of defined and further examined this test is J&DLA Piper UK LLP, and it was emphasised there by Lord Justice Underhill that whilst it's good practice always for a judge to make rulings on both aspects, so on the impairment aspect and the adverse effect aspect, it's not always necessary for them to take a rigid approach. And what can be done is that if there isn't a clear impairment, a judge can look at the adverse effect and then decide whether or not there's an impairment on that basis. So it doesn't have to they don't have to look at impairment and then make a judgment on adverse effect and based on their conclusion in respect of that. So the first case to look at is Koratchanova and Eurorep Limited, which is an EAT decision of Mr. Justice Chowdhury. Now, this case has quite interesting background facts, and the respondent was in the business of breeding insects and particularly crickets for reptile food, and the claimant was summarily dismissed for issues relating to management of a cricket colony. The claimant asserted that she was suffering from a disability which she termed mixed personality disorder, and there was a PH to determine that disability, and the employment tribunal found that she was not disabled on that basis. And in this case, the claimant relied on a medical report, and in that medical report it didn't actually include that she had a mixed personality disorder, but rather simply specified that she had some problematic personality traits. Now, the primary issue on appeal and the submission of the claimant's representative was essentially that the employment tribunal had placed too much emphasis on whether the claimant had a mixed personality disorder or not, and didn't look at the substantial adverse effects argument enough. And I bring up on the slide now paragraph 13, which sets out in summary that argument. Now, in response, Mr. Justice Chowdhury was very clear that argument could not stand, because whilst in the case of DLA Piper, there was almost an acknowledgement that the test can be considered the opposite way round, so the adverse effect, then impairment, there was no error of law to do it the way round set out in the statute, so looking at the impairment first and then the adverse effect. It was held that the tribunal was entitled to conclude on the basis of the medical report that as there was no diagnosis of the mixed personality disorder, the claimant hadn't kind of made out an impairment on that basis. So then the Employment Appeal Tribunal went on to consider whether or not the tribunal had properly considered whether there were any other impairments, because the tribunal hadn't expressed a specific conclusion on those points. And the tribunal held that whilst the EAT held that whilst the tribunal hadn't made a specific conclusion whether or not there were any other impairments, because they had gone on to consider whether or not the claimant was substantially adversely affected in her day-to-day life, and concluded that she wasn't based on in any aspect, so in relation to any impairment, then that satisfied the consideration of any secondary impairments that the claimant might have. And the Employment Appeal Tribunal also concluded that the perversity appeal failed as well, which was run alongside, and that the tribunal's decision was reasonable. So what can we kind of take from this judgment? Well, firstly, if you're relying on a specific impairment in relation to disability, you're unlikely to be successful if you have a medical diagnosis that isn't supportive of that. So if the medical diagnosis says something different. However, if you don't have any medical diagnosis at all, it's not hopeless. It's possible to rely on an other impairment or something that isn't defined. However, if you're going to do that, what this case demonstrates is the importance of having kind of specific evidence, particularly of the adverse effects, so of being unable to undertake normal day-to-day activities. And the claimant in this case was criticised in the first instance decision because she was unable to actually give examples of when her life was affected, and simply made assertions that it was, which was ultimately not affected by the judge. Again, it was emphasised that there must be a substantial adverse effect, which is more than just a trivial one, which is important to bear in mind. And a final kind of takeaway point was that it was briefly considered in the EAT whether or not a letter from DWP should have been considered further. And it was held that it was properly considered and taken into account as part of the evidence, but it wasn't necessarily determinative, because although it stated that the claimant was entitled to disability allowance for living, it didn't identify what impairment she had, and it could have been considered in the context of all the other evidence. So the second case in defining disability is Ahmed and Cardinal Hume Academies, which Karen appeared on behalf of the respondent successfully in. And this is again a case decided by Mr. Justice Chowdhury. Now, there was many different kind of appeal points in this case, so I'm just going to focus on the very specific point, which goes to the definition of disability. The background facts in this case was that the claimant was suffering from dyspraxia, so that caused difficulties with his handwriting, and the respondent was at school and he was employed as a teacher there. Now, the issue in relation to the definition of disability is as follows. The Employment Tribunal found that the claimant was suspended because he wasn't able to write due to hand pain, and that was a specific finding made. And then at an earlier preliminary hearing, the claimant was found to be disabled by reason of difficulty with handwriting, including hand pain. Now, the claimant argued in his appeal that the tribunal's failure to find a direct discrimination claim was wrong because he'd been found to be disabled by reason of hand pain, and the tribunal had found that he'd been dismissed because of hand pain. So surely, he says, that a Section 13 claim should have been made out. However, the respondent, and as summarised in this paragraph and as argued by Karen, emphasised that this was really an oversimplification, because what the judge in the preliminary hearing had found was that the disability wasn't the difficulty with handwriting. Really, the difficulty with handwriting and hand pain was the adverse effect. So that needed to be separated out from the impairment, which was unspecified in this case. And Mr. Justice Chowdhury, and that's set out at paragraph 62, wholeheartedly supported that argument, and concluded that the impairment had to be considered separately to the adverse effect, and the difficulty in handwriting was the adverse effect, not the impairment. Therefore, Section 13 direct discrimination claim couldn't be made out on the facts, because the dismissal was because of something arising from the claimant's disability and not the disability itself. So just to summarise, what we can take from this is the importance of not confusing mental and physical impairments with adverse effect. of course, it's best if we can to identify an impairment and an adverse effect separately. However, if you aren't able to identify an impairment, it may be that some thoughts needed to what type of claims you want to bring. It might be more difficult, for example, to bring a claim under Section 13 if you don't have a defined disability, because you need that direct comparison. And maybe a Section 15 complaint is more suitable in those circumstances. So the second topic is identifying PCPs. So I've just put on the slide there an extract from the Statutory Code of Practice, which identifies that PCPs should be construed widely and reminds us that they also apply to one-off decisions and actions. And of course, we know that PCPs are relevant both to reasonable adjustment claims and indirect discrimination claims as well. So that gives us a little bit of a background. Now, the recent Court of Appeal case of Isherlow and Transport for London dealt with explicitly how far PCPs can go, and particularly how far we can argue that a one-off decision amounts to a PCP. And in this case, the claimant argued that the practice which he said was made out, was requiring him to return to work without concluding a proper and fair investigation into his grievances. Now, the tribunal found at first instance that this was a one-off act in dealing with the claimant, and therefore there was no PCP. The EAT upheld that decision, holding that although there was a one-off act and that possibly could be a PCP, it wasn't always the case. And Lady Justice Simler agreed with both the tribunal and the EAT, and the slide sets out kind of the three key points of her judgment. Firstly, she emphasised that not every single example of unfair treatment can amount to a PCP, and there is some discretion to the tribunal to decide how far that goes. Secondly, she emphasised that there needed to be kind of some element of continuum. So in the sense that where there's a practice, it needs to be ongoing, either how things were done previously or how they will be done in the future. And particularly in a case where there's a one-off application, obviously that's something hasn't been done before, but there has to be kind of the suggestion that if someone in the future was in the same hypothetical situation, then the same decision would apply to them. And in the Isherlow case, the evidence was quite clearly that this was only a specific situation that applied to the claimant and wouldn't apply again in the future. So when identifying PCPs, we need to remember that not every single act or decision amounts to a PCP. So some effort needs to be, and some thought needs to be given to how a PCP is defined. Obviously, it's preferable if it can be established that it's not a one-off act or a decision, and that there's some evidence that this is the way things are usually done, and therefore that's easier to establish. However, if there's no escaping that this is a one-off act, then there needs to be some evidence that is likely to apply again in the future, or some suggestion of that. And also, probably that there's no evidence of any inconsistent practice which is likely to defeat such a suggestion. So moving on then to extension of time, and the Court of Appeal case recently on this point was Larry Beck Services Limited and Brophy, and this was dealing particularly with extension of time in a disability discrimination case. And although it's quite set aside factually, so it's really on its own facts, it is useful just to go through another example of the extension of time case and what sort of factors that a court is likely to apply. And just for reference, paragraph 12 of this judgment does give a very useful overview of the approach to the reasonable practicability extension test. And paragraphs 13 to 14 give a useful overview of the just and equitable test, which are useful to look back to if you have time and want a summary. So the facts of this case was that the claimant was severely dyslexic. He relied heavily upon help from his brother to bring his claims, and he was told by his employer at the disciplinary decision that he wouldn't be notified exactly at that point that he would be dismissed, but the decision would be deferred to a later event. He was telephoned on the 29th of June, informing him that he was dismissed, but he wasn't informed in writing until the 6th of July. And there was some confusion in the letter that he received, whether or not it was the date that he received the letter that was his date of dismissal, or whether it was when he received the telephone call. His brother, who was assisting him, assumed that the date of dismissal was the 6th of July and submitted ACAS, early conciliation, and the claim form based on that date. However, if time was calculated from the date of dismissal on the 29th of June, his claims would be out of time on that basis. The Employment Tribunal concluded that it was reasonable to extend time after finding that the 29th of June was the correct time, due to the fact that the claimant was a layperson, was relying on his brother due to difficulties of dyslexia, and it was reasonable because of the confusion with the dates. And the Court of Appeal upheld that decision, which was also upheld by the EAT, and it was held to be reasonable. And I set out the reasoning in paragraph 23 on the slide there for your reference. Now, what we can kind of take from that judgment is just a reminder that if a claimant is disabled and is relying on family and friends in bringing their claim, there is some leniency that should be given. There's also more leniency when there's a lay person and bringing a claim, and so the extension of time is more likely probably to be granted in those circumstances. And also it's the importance for respondents to remember that when communicating effective dates of termination, it's really important to be clear and consistent, so there's no confusion that the claimant could potentially rely upon to their advantage at a later date. So moving on finally to recommendations. Now, this is a topic that doesn't often come up necessarily in disability discrimination cases, but I raise it as there's been a recent decision about it, which might mean that it's more applicable in the future. So I set out on the slide section 124 of the Equality Act, which details when the tribunal may make recommendations. And of course, if a respondent fails to comply with that recommendation, they may be ordered to pay compensation. Now, the case that deals with recommendations is Hill and Lloyds Bank PLC. And this was another case where the claimant was disabled, and she suffered from reactive depression, and which resulted in bullying and harassment. She sought an undertaking from her employer after her return to work that she wouldn't have to work with the two individuals who bullied her, or in the alternative, if that wasn't an option, that she would be offered a redundancy package. The respondent refused, and the claimant brought a reasonable adjustments claim, and the Employment Tribunal upheld that. Now, the EAT kind of considered whether in principle such a recommendation could be made, and they considered that it could. And as set out kind of on the slide at paragraph 25, they said there was no objection to a recommendation which effectively meant that there were financial implications on behalf of the respondent. At 26, they set out that there's no objection to the fact that a recommendation might have indefinite consequences, and therefore that there was no reason in principle why there couldn't be a recommendation that the respondent give an undertaking. so what the claimant had asked for in the first instance. So what can we take from that? Well, really, the recommendations are quite broad. They can be drafted to have such financial implications and can apply for indefinite periods. So it's always useful to bear in mind if a recommendation is useful for your client. Okay, so that brings me to the end of my presentation, and I think it's time now for some questions and answers.
Thank you, Grace. That was an interesting whip through the most recent cases. Thank you very much. I think we do have time for some questions. Thank you to those people who have submitted questions on the Q&A function. I don't think we're going to be able to get through all of them, but I might take one of them first. It's from Pam Sidhu. The question is, where an employee has anxiety and depression and the only treatment is a low-level antidepressant for a number of years, is that clearly a disability under Section 6? Is it generally difficult to claim such conditions as a disability? What sort of medical evidence would be needed at a preliminary hearing? In my experience, it's extremely easy to claim a condition like anxiety and depression, particularly depression, as a disability. The bar for liability or for establishing a disability under Section 6 is set very low. The effect on day-to-day activities only has to be more than trivial. In my experience, where a person has a diagnosis of depression and that person has been medicated regularly, I would say they're very likely to satisfy the test under Section 6. In terms of what sort of medical evidence is required, I would say it's, again, relatively easy on the medical evidence, and I would consider that the GP records showing that somebody has had antidepressants prescribed for them, and obviously a disability impact statement would also be necessary to for the claimant to set out what day-to-day activities would be affected without considering the positive effect of the medication. I would say that claimant is more likely than not to be considered disabled. Grace, did you want to take another question? And then if we have time, I'll take another one after that.
Yep, of course. So I've got a question from John Withers here. So it's on the Korochalova case, and it's whether family members or friends can be witnesses at an employment tribunal as to the substantial adverse effect on normal day-to-day activity. And I would say, yes, I don't see any reason why they couldn't be witnesses as to PH, for example, as long as you notify the tribunal in advance, and particularly where there is such a need to show the fact that there is substantial adverse effect, and where there is a need to show examples. I don't see why friends or family can't be used to show that. And I particularly note, obviously, in disability discrimination cases, sometimes it's difficult for the claimant to be able to express just how much difficulty they have in day-to-day lives, particularly if they have a mental impairment which stops them from doing that. So I think that would be a good use in certain cases, definitely.
Yeah, I've had lots of experience of family members or even flatmates giving evidence on the substantial adverse effect. The only thing I would say is that if it's a spouse or somebody who's very closely related to the claimant, obviously you have to exercise some judgment as to whether you should call them, because sometimes they're so enthusiastic in support of the claimant that they stretch the evidence beyond the truth. So you might have to be careful how you select those witnesses. answer just one very quick question, because I think it's almost a one-word answer from Shahzad Ayub. Thank you for your question. In order for a claimant to succeed in a harassment related to disability claim under Section 26, would it need to be shown that the perpetrator thought the victim of the harassment satisfied the legal definition of disability in Section 6? Simple answer to that is no. Not at all, in fact, because remember that liability under Section 26 can be established without any evidence at all of the purpose of the perpetrator. So what's in the perpetrator's head doesn't really make any difference. It's about the effect on the victim. I don't think we've got time to do any of the other questions justice. Thank you for sending them in. That concludes our disability discrimination update webinar for today. Thank you very much for joining me and Grace virtually. We hope that you have found it useful. Please do look out for the 3PB Employment Group newsletter that has been released at the beginning of the week, and that's edited by the brilliant Sarah Clark. Also, continuing with our employment and discrimination webinar programme, there is another webinar in a week's time, so that is the 17th of September, with the fantastic Lachlan Wilson and Daniel Brown speaking on the subject of redundancies, obviously a hugely hot topic at the moment in the COVID situation we're in. Thank you very much. We look forward to seeing you again in the future, hopefully in 3D person, as well as perhaps by video. Thank you very much. Bye-bye.
Goodbye.